Welcome once again to Lehto's Law. Here's Steve Lehto.
A couple of people sent me the stories to see if you're going to talk about this because it is political and you often avoid political topics on your channel. And I've got to talk about this because it involves an attorney gone wrong. So, yeah, there's some politics here. I'm going to try to kind of go over that quickly because to me, the politics aren't the important thing here. It's how far someone can fall when they get into the public spotlight. From the New York Times, Colin Moynihan wrote it. Michael Avenatti is found guilty of stealing from Stormy Daniels. And you don't have to think back too far to a time when Michael Avenatti and Stormy Daniels appeared to be friends and holding press conferences and so on, and being in the news almost constantly. Well, it turns out they had a falling out, and Michael Avenatti has now got some issues with some convictions, which is not good if you're an attorney, and he is, in fact, an attorney. So 4 years ago, you'll recall the two of them being everywhere on the news. Now, Ms. Daniels is described here as a pornographic film actress. Said she had been paid $130,000 in cash just before the presidential election to keep quiet about things she had done with the candidate in that election. Her lawyer, Mr. Avenatti, filed a lawsuit in 2018 saying that a non-disclosure agreement that she had signed was void because the other side had not signed it. So all of this stuff was going on in the news, and it looked like these two got along well. And also, a lot of people thought that this Mr. Avenatti guy really looked like he had his act together. A lot of people said, you know, that's a good, determined attorney. I'd hire him if I had a need for such an attorney. A jury has now determined that as he was speaking about how badly Ms. Daniels was being treated by people in power, Mr. Avenatti was stealing from her. And that is what a jury in Manhattan found just a couple days ago. After deliberations that stretched across 3 days, and actually at one point looked like they may have been hung up, jurors convicted Mr. Avenatti of wire fraud and aggravated identity theft, agreeing with accusations made by the prosecution that he used a bogus letter to trick Ms. Daniels' literary agent into sending him almost $300,000 in publishers' payments that were meant for her. And we'll get into that because it's a little unusual. And I actually know about some of this and how some of this works. I've written books. I've gotten advances from publishers. So I know how this stuff all works. Mr. Avenatti, walking out of the courtroom, said, "I am very disappointed in the jury's verdict. I look forward to a full adjudication of all the issues on appeal." And of course, many people are going to say, Steve, doesn't it sound a lot like them saying like we can't comment because of pending investigations and so on? And of course, a full adjudication is what you just got, my friend. Adjudication is what happens in the courtroom. Now, on appeal, I guess you could say that's a form of adjudication. But as you go up on appeal, the issues get narrower, not wider. So Mr. Avenatti is scheduled to be sentenced in May, but he could get up to 20 years in prison on the wire fraud count, and he will get a mandatory 2-year term on the aggravated identity theft count. Jurors had indicated a couple times during their deliberations they're struggling to reach agreement, and after 4 hours of deliberation on Thursday, they sent a note to the judge saying they couldn't reach a consensus on one of the counts, and he encouraged them to keep trying. On Friday, they sent out a note saying that one panel member was refusing to look at evidence and was acting on a feeling, which you're not allowed to do. The judge told the jurors to continue deliberating, directing them not to be swayed by sympathy or emotion, and they came back with a verdict very quickly then. The conviction in federal district court is the latest blow to Mr. Avenatti, who's a brash California lawyer who became well known during his representation of Ms. Daniels. He appeared regularly on television, often with her, but apparently there's a time when the man always had a camera in front of him and he liked it. For a time, the two were stars in the lead up to that election, and some people really thought that these two were going to go places and accomplish things. And so, seizing on her renown, Ms. Daniels, who, by the way, her real legal name is Stephanie Clifford, signed a contract to write a book called Full Disclosure for St. Martin's Press. That contract apparently called for her to be paid $800,000. So $800,000 to write a book. And by the way, the book was written. I looked it up. It's on Amazon. It's got a foreword by Michael Avenatti, which probably seemed wise at the time. It was released in October of 2018. Since then, however, Mr. Avenatti's been a criminal defendant in several cases. He was convicted in 2020 of trying to extort millions of dollars from the athletic apparel company Nike. A lawyer representing him in that case later filed a notice of appeal. In a separate case, Mr. Avenatti was accused of stealing millions of dollars from 5 clients and of lying about his business income. That case resulted in a mistrial last year after a judge ruled that prosecutors had withheld financial data from the defense. If that outcome led Mr. Avenatti to believe he would salvage his reputation as a populist lawyer who helped underdogs, his conviction in this case might tarnish that a bit. The prosecutor told jurors during closing arguments in New York the defendant was a lawyer who stole from his own client. She thought he was her advocate, but he betrayed her and he told her lies to try to cover it all up. During his closing argument that he made himself, because he represented himself, Mr. Avenatti told the jury there was insufficient evidence to prove he had intended to defraud or to harm Ms. Daniels. He described the prosecution's case as being the equivalent of a plate being brought to you at a restaurant that looks fine except for one big cockroach in the middle. And he asked the jury, would you eat that dish or would you send it back? During the trial, prosecutors presented evidence that Mr. Avenatti had emailed a letter bearing what purported to be his client's signature to her literary agency, directing that payments from St. Martin's be sent to a bank account controlled by him. Prosecutors say that he then used that money on his law firm's payroll, plane tickets, restaurants, and a monthly lease of about $3,900 on a Ferrari. Although he eventually sent Ms. Daniels about half the money he got, prosecutors say she never got the rest. And that, of course, would be a problem. But the fact that he redirected her money without her permission, if he had done that, which it appears the jury thinks he did, that's a major problem, whether she got the money or not. He doesn't have a right to do that. So Ms. Daniels testified she had not given him permission to take any of her payments from St. Martin's. And she said he had repeatedly lied to her as she asked him to explain, where the money is and could she help him get it, or could he help her get it. Dozens of text messages between the two were displayed in the courtroom. They showed Mr. Avenatti promising to help Ms. Daniels and at one point saying he was threatening litigation against St. Martin's. So he tells her, I'll sue him if I have to, knowing that they've already sent him the money. That's the allegation. His scheme came to light then in February 2019 after Ms. Daniels spoke with people at the agency and at the publisher, who both said, yeah, we sent the money to your attorney. What are you talking about? So 3 months later, Mr. Avenatti was indicted. The trial had several unusual twists. On the second day of testimony, the judge granted Mr. Avenatti's request that he be allowed to act as his own lawyer. That allowed him to cross-examine witnesses, including Ms. Daniels. And in questioning his former client and comrade, he concentrated on her interest in supernatural powers, asking whether a dark entity had once entered her New Orleans home through a portal and about her claim that she could speak with people who had died. Ms. Daniels testified that a medium told her about the dark entity's visit, and she acknowledged saying she believed she could talk with the dead, although she could not explain exactly how. It just happens sometimes, and probably had many people in the courtroom going, so what? You can steal from somebody because they believe they can talk to the dead? She also explained her participation in a project called Spooky Babes, described on its website as a group of investigators, occultists, psychics, and healers that examines paranormal activity, including poltergeist phenomena, shadow figures, and physical attacks by invisible assailants. Other government witnesses, including Judy Regnier, the former office manager at Mr. Avenatti's law firm, who testified that the firm had been short on money. Elizabeth Beyer, a St. Martin's editor, who said that to her knowledge, Mr. Avenatti had never threatened the publisher with legal action, and one of the agents who's the president and managing director of the agency. He compared Mr. Avenatti's stature in 2018 with that of a folk hero, fighting on behalf of those who had not voted for the president. And he said he had accepted as legitimate the fake letter purporting to be from Ms. Daniels, in part because it came from her attorney. So several times during the trial, and this was his defense, Mr. Avenatti brought up an attorney-client fee contract between him and Daniels that said he would provide legal services for $100. The contract also said that if he helped Ms. Daniels finalize a book deal, he would be entitled to a reasonable percentage of the proceeds. The figure that was to be agreed upon between client and attorney, Ms. Daniels testified that no such agreement had been reached, and that is an issue. And here's the thing. There's so much here. I understand this, and a lot of it, we could get into politics, we could do all kinds of stuff. I want to discuss the attorney-client aspect of this. And I have an agent, believe it or not, and I have gotten book deals through my agent. And so what happens is I have an idea for a book. I talk to my agent about it. He goes, hey, Steve, I think I could sell that if you wrote it. And then we work a little bit on a presentation. He then pitches it to different publishers, and then he'll call me back and say, Steve, we got an offer from this person over here, whatever. We got an offer. And through him, we negotiate a book deal. The interesting thing is that my agent is not an attorney, and a lot of literary agents aren't. They are simply people who are extremely well-versed and connected in the literary world. So the literary agency that Stormy Daniels used is a very, very well-known, well-established, renowned literary firm that does a lot of big book deals for big famous people and good writers. So the thing about this is that Stormy Daniels, once she has a literary agency like this one on her side, does not need Michael Avenatti for anything with respect to that book deal. Now, he did write the forward to her book. That's something. I've mentioned before, I've got 2 books which have forwards written by Jay Leno. Jay Leno wrote the forwards to my books about the Turbine Car and about the Tucker. And that really helps sell the book. But the idea that you hire an attorney to work with your agent who works with the publisher is needlessly inserting somebody into the transaction that doesn't need to be there. And the idea that he's going to help her get a good deal, but she has an agency that's famous for getting good deals, doesn't make any sense at all. Now, you might say, Steve, but she agreed to it. She agreed to it. Let's assume that there was an agreement that said, I, Stormy Daniels, using my real name, of course, will hire you to represent me in the issues involving the news that was going around at the time. I'll pay you $100 for that. And he says, I'll take $100 for that. And then, of course, you have the discussion that says, by the way, if there's enough media interest in this, we can probably sell a book. We probably can. We probably can. And if she said, I will work out a deal with you later on that book deal, if we get a book deal, if that was part of the agreement, then that's the agreement. But the agreement didn't give a number. It just said we'll work something out. And so if you ever have a contract that contains a clause like that, it can be enforceable. But the problem is that it clearly calls for the 2 parties to agree on something later. Who'd have thought they'd be getting a $800,000 book deal? Because that is an actual pretty large figure for an advance on a book. But, of course, that's how newsworthy this was. So apparently the advance was $800,000. How much of that is she entitled to? Well, here's the thing. The agent who negotiated the deal probably got 15%. So she would then get 85% of that back. How much is her attorney entitled to when he inserts himself into a transaction where he's not needed? Is he entitled to more than 15%? Because 15% is what the agents got. And that's what agents get for a big deal like this. 15%, that's the industry standard. So would he get more than that or less than that? I think most people say, well, he probably deserves less than that, if he deserves anything at all. But the point is that if the agreement says we will agree on this, and you never agree, you cannot act as if you have agreed. So in other words, let's take this to its logical and natural conclusion. So I have an agreement with you that says that you and I will later agree on a fair number. You and I don't agree on something. The money comes into my possession. I cannot just take it. And here's the thing. Lawyers know this. Lawyers almost always have trust accounts which are overseen by the state bar. In Michigan, they do. And you have this trust account, and if money comes into your possession that is not yours because it belongs to a client, it goes into the trust account. It's not your money, it's their money. The bank is holding the money for the two of you. I control the account, but it's your money. So let's assume we get back to that where you and I had an agreement. We'd agree on how to divide up this money. We haven't reached an agreement, therefore I can't touch the money. So you say, Steve, we're at an impasse. What do we do? We now resolve the issue. I contact you and say, I've got the money in my possession. It's in my trust account. It's your money. You'll recall that we had agreed to later sit down and hammer this out. Can we do that right now? And hopefully you say, oh, the money's there. Great. Can I come by the office and get a check? Yes, you can. When you come by the office, we'll talk about it. Can we? Maybe we can do that. Now, let's suppose you're going to say, Steve, we all know what's going to happen here. Big chunk of money hits the bank, and then one person's going to go, no, I want all of it. I want all of it. Well, here's the thing. It does still belong to the client. If the client says, I want all of it, you got to give them all of it. Because this happens all the time. Attorneys and clients get in fights over money. If it's a fight involving fees for work performed, I say I'll represent you in court, and I send you a bill, and then someone somehow pays us money, and you owe me money, and I've got a bill here that says you owe me money, and I've got money right here. I still can't pay myself over your objection. I cannot do that in most states. So what would have to happen then is we have to resolve this between ourselves. In the meantime, I may have to give you the money. It's your money. It's your money. And I know that there's probably going to be some attorney in some state out there who goes, Steve, in my state, we're allowed to do this. If you are, that's fine. Ethically, take a snapshot of the moment in time. The money comes in from the literary agent and hits the trust account. I believe I'm entitled to some of it based on an agreement that the client and I are going to agree on something in the future. We haven't agreed yet. This money still belongs to the client. I have a perfect remedy in that if I give you all the money and you never pay me a penny, I can then sue you if I have to for money damages and say, hey, I was entitled to something. And hopefully the person will sit down with you and say, hey, I recognize the role you played in this because somehow you played a role in getting me an $800,000 book deal. But the point is that he cannot just take that money. However, the other thing I'm going to tell you is that I disperse funds from my trust account to clients. Okay? So a check comes in. I call my client and say, I got your check. I get permission from my client to put it in the trust account. I say the check is here. It'll be easier if I take the check and run it through my trust account rather than giving a check to you and having you run it through your account because chances are it'll take longer because it's a check from somebody that your bank's probably never dealt with in that sense before. My name is often on the check as the attorney for the client. So you got two parties in that part of the check. So there's all kinds of issues going on there. It's faster to run it through my account. But I also tell my clients in writing what the money is doing, where it is, how much it is. And if it's going to be dispersed other than 100% to my client, I give that to them in writing and have them sign a thing. So if my client owes me money, and we know if they do or not, if they owe me money, I'll say to them, we got a check for this much money. You owe me this much. I would propose that instead of cutting you a check for the full amount that is coming to you and having you cut a check back to me for the amount you owe me, how about I just send you a check for this and I cut myself a check for this and it's all taken care of in one transaction. And people agree with that. It's easier. But it creates a paper trail so that I have a document signed by my client, or I've got emails back and forth or texts or something. I've got something to indicate that they understood what was happening and they agreed to it. Guess how many times in 31 years I've had a client come back and go, Steve, you mishandled my money. Take a guess. It's a real easy number to pick. I wouldn't have raised the question if the answer wasn't 0. I've never had this problem before. So if he was telling the truth and had done this properly, what he would have done is, number one, he wouldn't have had the money in his account because he only had the money in his account, apparently because someone forged a document and sent it to her agent saying send the money to her attorney. But let's assume that that was what they're planning on doing. The second the money shows up in his account or that he gets the check, he is supposed to contact her and go, I just got your check. Do you want me to put it in my account and handle it that way, or do you want to come pick it up? It's your check. And if she said, run it through your account, you'd have something in writing that says that. And the idea that there's any logical reason why the money would be in his account and she doesn't know where her money is a problem right there. That right there blows my mind that the jury didn't just go, oh, he's guilty. He's guilty. He's got to be guilty. There's no possible way for that money to be in his account and for her to not know where it is. Except for, if she'd said, get the money, put it in your account and call me. Then between the time that he got the money, put it in the account and called her, there might be a little brief window there. But the point is that when she calls him and says, where's my money? And it's in his account, and he doesn't immediately say, I've got it, boom, game over. Game over. And I've mentioned this before, and I have people joke about this, but I point out that the first class on the first day of law school that I took was ethics. Ethics. We started law school, day one, first class, early morning, ethics. Okay? And you learn this ethical stuff from the get-go. And then you get tested on it later. It's part of the bar. You have to know this stuff for the bar. And bar organizations recognize that attorneys will be handling money and property that belongs to their clients. And as you can imagine, the temptation is great for somebody who either has a substance abuse problem, a gambling problem, or just massively bad financial problems. The temptation is great to say, I've got all this money in this account right here. I can use a little bit for a little while, and I'll pay it back later. And so they started doing this a while back where they monitor and regulate and look over the trust accounts. And the state bar follows this very, very closely. They don't want this to happen. This is the kind of thing that makes attorneys look bad. And I know you're going to say, Steve, there's a lot else going on in this story. The man was convicted of extortion with Nike, and he was accused of something else for which there's a hung jury, and now he's accused of stealing from his client. But, let's face it, there's a whole bunch of other stuff going on here besides just a nitpicky technical violation of the legal ethics. Because, quite frankly, you have to understand, he can still be chased for that by the California bar. They can actually come back and go, dude, you mishandled your client funds. That's a problem. But right now, he's got so many other problems that this one kind of pales in comparison. But getting back to the underlying meat of this story, she has a book deal, she has an agent, she has a publisher. There's no need, no reason to have an attorney in that transaction anywhere. And he appears to have inserted himself and then redirected money to himself and then didn't tell her the straight story as to what was going on with the money. And his defense later is, well, she owed me money because we had an agreement to reach a later agreement that we never reached. And that's a problem. And I know attorneys who are really, really good at this, who document everything. Everything. And this is the kind of thing where you drop a little memorandum of understanding and you say, I'm the attorney, you're the client, and we have an agreement that I was going to get a portion of the proceeds if I helped land you a big deal. You landed a big deal of this much money, and the two of us now agree that I'm going to get this. And if we agree on that number, we both sign it, I get this, you get the rest, boom, we're all happy. And you walk into court with Exhibit A, and Exhibit A is the document I just described. There would be no court case. There wouldn't be. There was no such exhibit. And the idea that he is this savvy attorney bulldog and somehow he didn't get that really blows some holes in his case. So Michael Avenatti is found guilty of stealing from Stormy Daniels. Sentencing is coming up. The man has really fallen far. And I remember when I first saw him on the news, the first few times I saw him speak, I thought to myself, this guy's pretty good. And I'll have to keep an eye out for him. Well, not so much. New York Times ran that story. Colin Moynihan wrote it. And it was sent to me by two people. Edward sent it to me, and Dave sent it to me with a little note. And he said, Steve, who'd have thought strippers are more honest than lawyers? What can I tell you? Thanks a lot. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. I'm playing all the right notes, but not necessarily in the right order.